Well, I believe I am live right now and that you can hear me and that I can see your questions. So, welcome everyone. Thank you very much for joining me on this session. For those joining us now, my name is Lior Samfiru. I'm the employment lawyer. And why does that matter? Well, it matters because I'm here to talk to you about employment law and answer your questions. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta. Our job is to help employees navigate the maze of workplace laws. So what I do here every Wednesday at this time is I log on. I'm live, you're live, and I'm here for one purpose only: to answer your questions. You have an opportunity now to pick the brain of a top employment lawyer so that you know what to do if you are facing a workplace dilemma, a workplace scenario, if you have an ultimatum that was given to you by your employer. Maybe you're worried about losing your job. Maybe you have lost your job. Or maybe there's something you've always wondered. Maybe, can my employer do this? Well, if you want to know if it can and what you should do and how to respond, this is the time to ask those questions. I'm live to help you, to make sure that you walk away with answers after this session. Now, you have your keyboard there. If you type it in, the question, you press enter, I'll see it, I'll answer it. That's how easy it is, so take advantage. Now, before we get started today, let me give you some additional contact information. I can answer your questions here on social media. I can't actually do anything to help you. I can't deal with your employer. I can't represent you. To do that, you got to contact me directly or my team. To contact us, all you have to do is go to employmentlawyer.ca. You see that address below me, employmentlawyer.ca, the place to go to. You'll see phone numbers there, email addresses there. If you want a private email exchange, or just make a call or fill out a form, whatever you want, it's all there. So that's taking it to the next step beyond just this discussion on social media. So please take advantage of that, and I look forward to hearing from you. Taking that first step and asking a question today is extremely important. That next step, that second step, probably even more important to actually get us working so that you can get your workplace problem resolved. But that's for later. For right now, I'm live. I know you're there as well live, so welcome. My name is Lior Samfiru. I'm the employment lawyer here answering your questions live. So again, what a great opportunity to take advantage of that. If you've always wondered about something, no need to wonder anymore. Just ask the question. I'll answer it. As simple as that. Now, while we're waiting for our first questions to roll in, let me kind of list a few things, and we'll list them between the questions of things that you should never do without talking to me first. So the first thing I'm going to put on this list that you should never do, at least not without talking to me, is if you're laid off temporarily, just sit at home and wait to be called back to work. Never want to do that. Certainly not without having a discussion. And here's why. You have to remember that an employer does not have an automatic right to put you on a temporary layoff. So if you are put on a temporary layoff, you will have the ability to treat that layoff as a termination of employment. You don't have to sit and wait and hope that they call you back. You can, but you can also say that by putting me on this layoff, employer, even though you're looking at it as a temporary layoff, I, the employee, am choosing to treat it as a termination. And now you have to pay me my full severance. Now, why do you want to consider doing that? The reason you want to consider that, one of the reasons, is if you wait at home and then they call you back, by doing that, you've given the company the right to do it again. And that's a huge problem. I told you your employer doesn't have a right to lay you off temporarily. But if you let it happen, they then have the right to do it again and again and again. So you may be in a situation where you finally get called back to work. You're happy. Okay, thank God I'm going back to work. You work for a little bit and then you get laid off again for a few months. And then that happens again and again. And then you won't be able to do anything about it because you let it happen that first time. So that's why I said, if you're put on a temporary layoff, you don't want to just sit and wait to be called back and hope for the best. Let's have a chat. Let's talk about, do we want to pursue your severance? How much severance you're owed? Usually it's very straightforward to do that. And for many people, it may be better to do that. Get compensated, get severance, and move on, rather than allow the company to lay you off temporarily repeatedly. Hopefully that makes sense. For those joining us, welcome. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. I'm here live answering your questions, making sure that you know what to do in workplace situations. I'm going to start answering some questions right now. Please, you got time. We always get a lot of questions right at the end of the session, and I don't get to answer them sometimes. So take advantage. We have time now. Don't wait till the end. Do it right now. So our first question comes from Callie, who asks, my company is restructuring and I've been let go. I was told because they are a small company, I'm not owed anything. Is this true? Now, this is one of the most common misconceptions out there when it comes to employment law, and that is that only large companies have to pay severance, that a small company doesn't. Nonsense, ridiculous, completely false. So yes, Callie, of course your employer has to pay you severance. In fact, the size of the company doesn't matter. Whether you work for a company with 2 employees or 2,000 employees is not going to impact your severance. Your severance is based on a few factors. The main factors are your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more you're owed. So, Callie, I don't know how long you've worked, and I don't know the type of job, but you could be owed as much as 2 years' pay, 24 months. So, yes, you are owed severance. If you're not paid that severance that you're owed, that's a wrongful dismissal. So what you need to do is you need to give me a call. Okay, let's have that chat. To connect with me, Callie, or anyone else, employmentlawyer.ca, the place to go. Again, employmentlawyer.ca to connect with me. All the contact information is there. But that's a great question. And same with you. If you're working for a small, maybe kind of a mom and pop type of a shop, and you think that, well, I'm not owed any severance if I lose my job, that's wrong. Yes, you are. In fact, you're going to be owed the same as if you were working for a huge company. Okay, great question. I'm going to continue answering some questions. Next one just came in on YouTube from Keith. Keith asks, I was over the age of 40. I was with this company for 16 months, and I took a leave of absence for disability, and they fired me saying they can no longer accept my doctor's note. That's nonsense. They don't get to decide if they accept your doctor's note. They don't have a say in that. If you provide a doctor's note saying you need to be off work, then you need to be off work, and they don't get to question that. They don't get to deny it. They don't get to get a second opinion. None of that. So by saying too bad, we're going to let you go, we don't care about your doctor's note, number one, it's a wrongful dismissal. But forget about that. That's also a human rights violation. Okay, it's illegal. They can't do that. So Keith, you and I sounds like have a lot to discuss here, because not only do they owe you severance, and even after 16 months, you could even easily be owed 3, 4, 5, even 6 months of severance. But you're also potentially owed human rights damages because of what they did and how they treated you. So Keith, you and I need to have a chat. I want you to connect with me and my team through employmentlawyer.ca. You see that address right there, employmentlawyer.ca. You'll see the email address there, the phone number is there. So take that next step, Keith. It's certainly not something you should ever let a company get away with. Okay, so thanks for that, Keith. Happy to chat. Next question just came in on YouTube from Archie. Archie asks, what can someone do to prove harassment is going on in the workplace? My nephew has been struggling with this and is worried that it will be his word against theirs. That's a great question, and that is a concern. Whenever it's your word against someone's, it's not a good situation if you can avoid it. So how do you prove harassment? There's a number of ways. Number one is you can record things that happen, and you don't even have to tell the company that you're recording. So you can have a recorder on your desk, on your coat pocket. As long as you're part of the conversation that you're recording, then it's perfectly legal. You can't record someone else's conversation without them knowing. But if I'm talking to you and I'm recording this conversation, that's fine even if you don't know it. So that's one way. Another way is to send an email to the person that's doing the harassing, confirming what just happened. So let's say the boss just told them all kinds of nasty things or whatever it is. Send an email. Hey, I confirmed today you told me these things. I don't appreciate that. Create that written record. Okay, create that record. It could even be as simple as having a journal where you write down what happened contemporaneously, not later on. So you had a meeting, you go back and you write down what happened. That gives it credibility. So those are a few ways to prove harassment. But to simply say, Bob harassed me, you can assume that Bob is going to say, no, never happened, right? Bob is not going to admit it. So that's why it's important to create some record and have some evidence. It's not hard. You can be a bit creative, recording, email, having notes, all those work really, really well to create that record, okay? If he's still struggling with this, have him give me a call, okay? Let me talk to him at employmentlawyer.ca, the way to do it. So thanks for that question, Archie. For those just joining us, my name is Lior Samfiru. I'm the employment lawyer, and the reason I'm here, the reason you're here, hopefully, is because I'm answering questions about employment law. I'm telling you about workplace rights. I'm telling you what you need to know if you're facing a workplace problem. So I am live right now. Ask your question. Take advantage of me being here and ask those questions. Man, he must have heard me say that. Rocket on YouTube just asked, is using profanity in the workplace, whether direct or indirect, cause for dismissal? Generally, no. So here's how it could be cause for dismissal. If you use profanity and your boss gave you a warning and you used it again and they gave you another warning, you did it again, then they said, okay, enough, final warning. You can't use profanity, and if you do, we'll let you go. And then you did it again. Then at some point that employer can say, well, what more can we do, right? We gave you warnings, we gave you a final warning, you're not getting it. So then maybe that could be cause for dismissal, meaning your employer doesn't have to pay you anything. But if you use profanity and the employer turns around and says, I heard you use profanity, that's cause, goodbye. No, that's not cause. So, it is difficult to establish cause. You really, if you're the employer, you have to show that you've done everything you could to fix the problem, and you just can't fix it because the employee is not doing their part. Then and only then can you establish cause. But simply saying, I heard you say the F word at work, not appropriate perhaps, but certainly not going to be cause for dismissal in itself. So hopefully that makes sense. Rocket, if you have a follow-up question, let me know. In between your questions, by the way, waiting for that next question. Have it come in right now. Ask me the question. Take advantage. Don't wait till the last minute. But as I said, in between your questions, I'm listing a few things that you should never do without talking to me first. And the next thing is you should never assume that you're an independent contractor. Okay? Gosh, what an opportunity to get into trouble by making that assumption. And the reason I say that is that most people that think that they're independent contractors are really misclassified. They are really, in the eyes of the law, employees. So if you have a regular job, you go to work, you do your job, you come back, you go back the next day, do the same thing, but you signed a piece of paper saying you're a contractor, you pay your taxes as a contractor. No. You're not a contractor. You are an employee, and you have the rights of an employee. You also are probably paying your taxes illegally because you really are an employee, so that could be a problem as well. Now, why is that important? It's important because if you are an employee but you've just been misclassified, then number one, you're owed things like vacation pay, you're owed overtime, you're owed a holiday pay, minimum wage, but especially you're also owed severance. So an independent contractor, when they lose their job, generally are not going to be owed severance. But if you're misclassified, but you really are an employee, then you better believe you are owed severance, as much as 24 months pay. So don't make assumptions, at least without talking to me. If you make an assumption, you lose your job, you'll assume, well, I don't get anything, I'm an independent contractor. And you could be walking away from maybe tens of thousands of dollars or more in severance that you are legally owed. Okay? So the question to distinguish an independent contractor from an employee is, are you in business for yourself or do you work for the company? If you have a bunch of clients or customers that you do work for, and you decide where to go and who to work for and how much time to spend, then yeah, you're probably an independent contractor. If you work for one company, you're almost always going to be an employee, regardless of what they call you, what you call yourself, what you sign. None of that's going to matter. Okay? So keep that in mind. Any questions, ask me. Happy to chat. And again, to connect with me off social media, to have a private chat or a private email exchange, easy. Just go, you see it right there, employmentlawyer.ca. Again, employmentlawyer.ca. Connect with me, my team. All the contact information is there. Next question today, ask yours too, by the way, comes from Benedict, who asks, can your employer refuse to let you take a vacation? We're understaffed and my request keeps getting denied. So your employer is able to schedule your vacation. Your employer is able to decide when you take your vacation, okay? And they don't have to approve the vacation when you ask. So you say, well, I want to take vacation in July. They can say no. They can also reject it in August. They can say, well, your vacation has to be in October this year. You're not going to be happy because you don't want to take vacation in October. You want to take vacation in the summer. But legally, they can do that. What they can't do is say, you're not getting any vacation this year. That's illegal. That's a breach of employment standards. But they can decide when. Now, a lot of employers don't do that because they want to have happy employees. So they want to give employees a say as to when they take their vacation. But strictly speaking, from a legal standpoint, your employer can decide when you're taking vacation. So, Benedict, hopefully that answers the question. Any follow-up, you know what to do. Just ask. I'm here, not going anywhere for a while longer. So ask away. Same with you. We're just over halfway of this on this session. Don't wait till the last minute. I know I always get 3 or 4 questions right at the end. Don't do that. Ask now. Next question on YouTube from Fortress Maximus. Can my employer ask for a list of my medications? No, absolutely not. Your insurance company could. So, for example, if you're covered by a disability plan through an insurance company, that insurance company can ask what medications, absolutely. But your employer cannot, should not, and it's none of their business. Because whether you're suffering from cancer or depression or a bad back does not matter. What matters is whether you can do the job. So that information about your medical, your medication, your prescriptions, not proper. It's completely offside. Okay, hopefully that makes sense. Okay, follow-up question from Rocket on YouTube. Third-party delivers applications like Uber Eats and Skip the Dishes call their drivers independent contractors, even though they really rely on the company. They rely on the company financially. What does the law say about this? Well, we'll find out. I'm involved right now in a huge class action against Uber, the purpose of which is to have our court determine that they're employees. So we will find out what the court's saying. In other jurisdictions, in the U.S. and in Europe, at least with respect to Uber, courts and tribunals have found those drivers to be employees. We'll see what happens here. The case is going on right now, and at some point we will have guidance from our courts. Obviously, because I'm the one heading the case, I believe that those individuals are employees and they have the rights of employees, and I believe we will be successful. Time will tell. That's why we have a legal system here, and these cases, unfortunately, don't necessarily move quickly, these class actions, but the case is going on, and we're pushing it as hard as possible. So hopefully that makes sense, Rocket. Thank you for that question. Again, we have some time, guys, so ask your questions. By all means, take advantage. And as I said, in between those questions, we've had some great ones today. I'm going to list a few things you should not do without talking to me first. Well, you know what? Before I do that, I'm going to take questions. Our questions are top priority. Your questions are top priority. So next question comes to us on YouTube from Ryan. I'm starting a new job on the 13th of May. Congratulations. I have the job offer from the company, but I am thinking twice before signing it. What is the cost for your company to look over my job offer and give me some ideas? First of all, you should never, okay? In fact, that was one of the points I was going to say. You never do something without talking to me. You never sign an employment agreement without talking to me, because I can guarantee you there are terms in that employment agreement that are going to be very problematic to you. Okay, so a lot of people just look at, well, what is the hour? What am I getting paid per hour? It's my salary. How many weeks vacation? There are many other things that are problematic. For example, something that could limit your future severance, something that allows the company to lay you off temporarily or to change your job. Many other things as well. So never ever sign one without getting advice. And guess what? You can negotiate these terms. We'll talk to you about how to do that. Usually, in terms of fees for something like that, you're looking at an hour's time. So an hour's time, depending on the lawyer. But my gosh, it's well worth it. We've saved individuals hundreds of thousands of dollars over the years by reviewing that and helping them negotiate better terms that save them a lot of money. So thank you, Ryan. Okay, so Ryan, yeah, so I see you have some follow-up questions. I've answered it. Give us a call. Again, to connect with me and my team, Ryan, easy to do, employmentlawyer.ca. Again, employmentlawyer.ca, the place to go to get the phone number, email address. We can help you with that employment agreement. Not a problem at all. So next thing you never do, by the way, without speaking to me first. You should never do. And this is the big one. This is maybe the biggest one, is you never, ever sign a severance letter or severance offer without talking to me first, okay? There's no exceptions to this. Never, ever. Now, 90% of people, when they're let go, regardless of the reason, that severance that they're offered is a lot less than what they're actually owed. And I say 90%, I think I'm being kind of conservative. It's probably even more than that, but say 90%. And I'm not talking that it's a lot less than what they're owed, that they're owed 6 months pay and they've been offered 5. No, I'm talking that they're owed 6 months pay and they're offered 6 weeks pay or less. So chances are that you are owed a lot more than what you've been offered. Even if you work for a good company, even if you work for a big company, even if you have a good relationship with the owner, doesn't matter. Oftentimes, the company doesn't understand how much they're owed. So what do? You contact me. Let's have that chat. The problem with you signing that offer is if you sign it and the next day you realize you made a mistake and you wrote an extra $50,000, you can't go back. Okay, you can't change your mind. You can't say, I was under pressure. You have to get that advice before you sign. Let me make it even easier for you to get that advice. Okay, if you want to know now or at any time how much severance you are actually owed, not what the company's offering, how much severance you are actually owed, here's what you do. You grab your smartphone, your tablet, your desktop, doesn't matter, and you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that right here, right here. Now, at pocketemploymentlawyer.ca, we have our severance calculator tool. That's what it does. It calculates your severance, tells you how much severance you are owed. It's anonymous. It's free, 100% free. It's easy to use. You just answer a few questions from a drop-down menu and you are done. It's going to tell you whether you're owed 20 months, 6 months, 18 months, or anything else. It's something it's vital for you to have. Even if you haven't lost your job, but you're worried about losing your job, or maybe you're just curious. By the way, it's not a week's pay per year of service or 2 weeks pay per year of service. Don't believe me? Check out pocketemploymentlawyer.ca. Okay? So you never do that without talking to me first. All right. But right now I am live. So you can talk to me now. Ask your question. We have some time left. Next question to us comes from Elaine on Facebook. What are your thoughts on those denied EI who were put on an unpaid leave because they wouldn't take the jab? My thoughts is that we can resolve that easily. We need to get your employer to issue you a new record of employment that would allow you to qualify for EI. Remember, EI is just following directions. If your record of employment is filled out in a certain way, they're not going to approve you. So we need to get you a new record of employment. It's not that hard. We've been doing that for many people across the country. So if you're let go and if you've been denied EI, then yes, let's get to work and get you EI. The other thing is if you're let go or put on a leave, you can treat that leave as a termination. You can get severance. Okay, so there's the issue of the EI and the record of employment, but there's also the issue of severance that you're owed. So for both those things, we need to chat, Elaine. So whether it's you, your friend, your colleagues, call me, contact me. All you have to do, go to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information is there, phone number, email address. So take that next step, Elaine. And again, thank you very much for that question. Next question, though, right now on YouTube from Julia. My employer has been changing their work from home options recently. After telling all staff that we would have remote work options going forward, what types of changes are they allowed to make? So generally speaking, unless they promised you that you can continue working from home, an employer can require you to go back to pre-COVID work arrangements. So if pre-COVID you were working from the office and during COVID, because of COVID, you were working from home, the employer can say, well, now we want to go back to the way things were before the pandemic. Now we want you to go back to work. Now, on the other hand, if during the pandemic they said that even after COVID, we're going to continue working from home, and if you can show that that's what they've said, then they have to live by that. And if they change their mind, that could be a constructive dismissal. So comes down to, did they promise you, did they tell you that even after the pandemic, you're going to be able to work remotely? If so, then yeah, constructive dismissal. If they never said that, but you were working from home during the pandemic, they can require you to go back to the way things were before. Hopefully that makes sense. If you have a follow-up question, let me know. Happy to chat. Elaine asks a follow-up question. Can you collect EI and receive severance? So generally speaking, you can't get severance and EI for the same period of time. So if you get severance, EI is going to kick in after the severance runs out. But oftentimes there's ways to classify the severance in a way that doesn't impact EI. So that's another reason 2045, why you have to contact an employment lawyer like me, like my team, if you lose your job, if you're put on a temporary leave, if you're suspended, because it's about ensuring that you get the maximum amount of compensation that we can legally get you. Okay, so hopefully that makes sense. Let's see. Let's take another one of my list for things that you shouldn't do without talking to me first. And that is, next one is, you should not just accept changes to terms of employment. So if your company wants to change your hours or your pay or your job, the problem if you just accept that is that, number one, you're stuck, but number two is you've potentially given the company the right to do it again. So let's say they give you a pay decrease and you're not happy. Who's going to be happy with the pay decrease? But you're thinking, you know what, I'll be the good soldier, I'll accept it and continue working. It's not that bad. Okay, that's great. Okay. But the problem with that is, by accepting that pay decrease and continuing to work, you've now potentially given the company the right to do it again and again and again. And next time they reduce you, and the next time and the next time, you won't be able to do anything about it. You can quit, but you don't get any compensation. That's why whenever your employer changes the terms of employment, you may have the option to treat that as a constructive dismissal. Okay, you may have the option to say, I'm not accepting that. And if you're going to force this change, I'm going to treat that as a termination, and I'm going to require you to pay me my severance. So that is an option in many cases where the company changes your job, your hours, your pay, your work location. But we need to talk about it. So that's why I say, if you're facing changes to your job, to whatever those changes are, don't just continue working and accept them without speaking to me first. Okay, we need to have that discussion. You need to understand your options, and you need to understand how not to be stuck in a bad situation. Okay, so definitely something that we need to do. Constructive dismissal is something that happens often. And I've gotten many calls over the years from people that said, my hours were changed a couple of months ago and I continued working. Now I realize I really hate that. What can you do to help me? At that point, I can't do anything because it happened a couple of months ago. By now, they're considered to have accepted those changes. So don't let that happen to you, okay? Don't let those changes become your new reality, and then you are stuck and potentially could face them again and again. So that's very, very important to understand. Now, I've given you some contact information. I'll close with that contact information as well. Good questions today, but if you want to follow up with me off social media, easy to do. All you do is you go to employmentlawyer.ca, again, employmentlawyer.ca. You'll see all the contact information there. You can contact me by phone, by email. It's all there. And if you want to have a chat, then we'll have that chat there. I will be back next Wednesday, and my colleagues will be on social media even before then, but don't wait until then. Contact me at the office at any time, employmentlawyer.ca. Happy to chat. You can send an email even if you don't want to pick up the phone. It's all there. Always been a pleasure to be here with you guys and answer questions and hopefully make you feel a bit better about workplace law. I'll be back to do that. Until then, take care of yourselves. Enjoy the nice weather, and we'll talk to you soon.